Welcome once again to Lehto's Law. Here's Steve Lehto.
Story was sent to me, and I looked at this, and I was like, whoa, that's a strange one. That's a strange one. I poked around to see if this has been reported anywhere else, and it has not been widely reported, but it will be. It will be. So I'm making this video at the beginning of the week. Let's see how long it is before this story is wall-to-wall on the internet, because it's going to be. So I'm taking this from a press release, actually posted by the Mendocino County District Attorney, speaking about something that happened in Ukiah. Alleged DUI driver found not guilty. So a man was arrested on the charge of DUI, went to a jury trial. The jury found him not guilty. His argument was not that he wasn't drunk. It was that he had to drive to save his own life. And a jury bought it. So a Mendocino County Superior Court jury returned from its deliberations Friday to announce that it found the trial defendant not guilty as charged. And by the way, this press release coming from the district attorney's office, you have to understand this. This isn't the attorneys for the guy who got off crowing about their victory. In essence, it's the district attorney's office saying, oh, we lost a case, here's what happened. So you got to give him credit for that. The man in this story is 60 years old. He was found not guilty of driving a motor vehicle under the influence of alcohol and not guilty of driving a motor vehicle with a blood alcohol content of 0.08 or greater. Okay, so there's two charges. They charged it two different ways, and he's found not guilty on both of them. The interesting part of this story is the defense. The defense in the case was that the man was driving as an act of necessity. It was necessity, thus justified under the law. What facts led to a man with alcohol in his system at that extent getting in his car and driving, getting caught by the police and a jury saying, that's okay, not guilty? Testimony was presented. The man had been caught in flagrante delicto by his wife, and his driving away was necessary to allow him to escape two angry women. Now, in flagrante delicto literally means in the very act of wrongdoing. It usually has a connotation of doing adult things and getting caught therein. But technically speaking, it simply means to be caught in the act. So he was caught in the act by his wife. I don't need to tell you the act, do I? You got that, right? Okay, just checking. He was caught in the act by his wife and was driving away to escape two angry women. Now, we can read between the lines a little bit here, because obviously we understand why his wife is upset. The question is, why is the woman he was with before the wife arrived upset? Did she not know there was a wife? Or was she upset in that you told me she wouldn't be home till tomorrow? That kind of thing. So we don't know. But he said that his driving was necessary to allow him to escape two angry women. And by that, he's saying that I felt my physical safety was threatened. And to protect myself, I got in a car and drove away. And the fact that I had alcohol in my system, hey, that's too bad. But I took the risk because that risk was less than the risk of what was going to happen to me if I stuck around with those two angry women. By the way, once you leave, if they start talking, you're in even worse trouble. But we'll get to that. While the prosecution argued the law of necessity is not intended and has never been applied to such a factual situation, the trial judge nevertheless allowed the jury to consider the necessity defense as a possible justification for the driving of under the influence. And so that's the thing, is that there are times in the law where somebody does something and says, I had to do it because the situation demanded it. And it's not that often that it's simply necessity, which is that the threat of what I did, the threat of danger, was less than what would have happened if I hadn't done it. And that's really what it boils down to. So the trial judge instructed the jury that the man had to have acted in an emergency to prevent a significant bodily harm or evil to himself or someone else. He had no adequate legal alternative. Like he could have waited 6 hours till he was sober and gotten in and drove away then. Of course, he wouldn't have lasted that long. The defendant's driving under the influence and or with a blood alcohol content did not create a greater danger than the one he avoided. So you can't say to avoid doing this, I did this and it's worse. No, that's worse. And to avoid that, I did this, which is not as bad. That's the key. When the defendant acted, he actually believed that the act of driving under the influence and or with blood alcohol content was necessary to prevent the threatened harm. A reasonable person would also have to have believed that driving under the influence and or with that content was necessary, and the defendant did not substantially contribute to the emergency. Believe it or not, that's what the prosecutor should have argued. Why was he in this situation? Whose fault was that, as I like to say? So the guy is having a meeting with a woman who ain't his wife. And when the wife walks in and sees how they're meeting, she goes crazy. Question is, did he substantially contribute to the emergency? Now, he's going to say the emergency is more narrowly defined. The emergency is not my wife walking in and catching me. The emergency is when she turns around and starts hitting me or starts swinging something or starts looking for something to hurt me with. That's the emergency. So the law enforcement agencies that investigated the case were the Mendocino County Sheriff's Office, California Highway Patrol, the California Department of Justice Forensic Laboratory. The prosecutor who presented the people's evidence to the jury and argued the necessity defense was inapplicable was the deputy district attorney. Mendocino County Superior Court Judge Carly Dolan was the trial judge who presided over the 4-day trial. So you can compare and contrast this case with the other case out of Texas, I believe it was, where the man had a really good defense argument, and the judge said, I'm not going to let you make that. Not going to let you make that argument. And so the guy went to trial, and he couldn't raise the most obvious defense, and he lost. And on appeal, the court said, you know, if a guy's got a good defense, you kind of got to let him use it. I mean, there are arguments to be made why you did things. And so they're saying they've never seen this raised before, and quite frankly, I don't think I've ever heard it raised before either. And I don't know necessarily what other kinds of cases you could have had, but I can imagine some now that I stop to think about it. You know, so suppose one day you're at home and you're drinking in the privacy of your own house. You're sitting there drinking. And somebody gets physically injured. They get hurt to the point where they need medical emergency. You run to the phone, you call 911. You can't get through. It turns out that the 911 system has crashed. You cannot get through on the phone. Cell phone, landline, I don't care. Nothing you have can help you reach the emergency people. You say, you know something? I think I'm sober enough to drive. Get in the car. You load the injured person in the car, drive them straight to the hospital. At the hospital, they get the treatment they need. Cop walks up to see what's going on. Next thing you know, you've been arrested for DUI. And you say, I had to save this person's life. Let's assume it's an actual dire physical injury, okay? I can see that argument. I can see the argument. And by the way, one of the interesting things about it is when they talk about the harm you caused versus the harm you avoided. And if you drove to the hospital or escaped the women and didn't cause an accident, and you literally just got someplace to stop, shut the car off, yeah, you broke the law. You broke the law, but you didn't cause any harm beyond that. So that's the interesting thing. So this story, like I said, kind of surprised that it wasn't more widely reported, but like I said, it was simply on the Mendocino County District Attorney's Facebook page with the press release, and then I followed all the links, and it appears to be real. So there you go. So it happened in Ukiah, I hope I'm pronouncing that correctly, California, but the alleged DUI driver found not guilty due to the defense of necessity. He had to do it to escape 2 angry women. Not 1, 2 angry women. There you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Real education starts when you realize that life is wild and you know nothing about it.